Good afternoon, everyone, and welcome to the Latham & Watkins Wednesday Forum. Today, our forum is both a preview of the coming term at the court with a little bit of review of last term, which was busy and significant, and there's nothing else going on. So we're going to be talking about the non-delegation doctrine in depth. I'm sure that's why you're all here. I'm joined up here with a fantastic group of panelists to help dissect the court's term, where the court is as an institution, and we'll try to leave a little time at the end for questions from the floor. So to my immediate left is Melissa Arbus-Sherry. She is at Latham & Watkins, where she argues appeals and has argued cases in the court as well from her time in private practice, but also in the Solicitor General's office. She was a law clerk to Justice John Paul Stevens, and before that to Judge Diana Gribbin-Motz on the Fourth Circuit. In the middle is Allison Newton-Ho, who is a partner with Gibson Dunn in Dallas, also has a busy and successful appellate practice. In fact, argued one of the cases we'll be talking about, the Oil States case, last term. Allison clerked for Justice Sandra Day O'Connor, and before that clerked for Judge Jacques Wiener on the Fifth Circuit in New Orleans. And last but not least is Emily Bazelon of the New York Times Magazine, a journalist who has written and spoken extensively about the court. She's also a lawyer and was a law clerk to Judge Lopez on the First Circuit. So I've kept the introductions very short so that we could squeeze in way too much material for the discussion. I wanted to start with an open-ended question, and one that is probably on everyone's minds, but to frame our discussion, I wanted to ask the panel, regardless of whether Judge Kavanaugh is confirmed, what does his nomination, the reception of his nomination, mean for the selection of future nominees at the court, the Senate's confirmation process, and more broadly, the court as an institution? Emily, do you have thoughts?
Yeah, sure. First of all, thank you so much for having me. It's great to be here with all of you on this quiet news day. I think that when Judge Kavanaugh was nominated and throughout the summer, we were having a conversation as members of the legal community, as citizens, about what it means when a swing justice, Justice Kennedy, is being replaced by someone who would seem to have a much clearer conservative ideological bent, what that meant in the kind of aftermath of Merrick Garland's failed nomination. We were having a really interesting conversation about law and process. And now we're having another conversation about character and upbringing and the past and what it means when your past from your youth comes back and haunts you in the middle of this process. There's a new accusation. A third woman has come forward today. She's making not a direct accusation about actions of Kavanaugh's toward her in terms of assault, but saying he was at parties where at least according to her, some awful things happened. So what do we do about that now? From the point of view of the Democrats and I think also people who are kind of concerned about process, there are big questions about what a fair and deliberative confirmation process looks like. And the idea of having one woman testify tomorrow and then the Judiciary Committee take a vote on Friday, I think as law students you can ask some questions about whether you think that is a fair and deliberative process, especially in the context where someone who says that he is innocent of all these accusations and in fact has said that he, was not a hard drinker in high school and college, contrary to other evidence on his own record, on the record of his friends, people coming forward. Whether we think that having all of that happen without an investigation is really a proper way to proceed, and if you were intent on clearing your name, would you really be resisting an investigation right now? So that's a question I have. On the other hand, I think from the point of view of the Republicans, this looks like a late-breaking news story, and one that is unfair in the process because of its timing. And one thing that I actually have been surprised by in the last week is the fact that at least when the second woman making accusations, Deborah Ramirez, came forward, it seemed as if Kavanaugh supporters were actually doubling down, and that suggested to them there was this, in their words, smear campaign that was happening that was somehow planned. It looks to me like a very haphazard kind of set of events. Like if you were planning this is not really what it would look like if you were planning it. But I don't have the same political leanings as the people who are convinced of that. And so those are the sort of two sides of this fight. It is going to be as much a fight about process as about substance right now. And another thing to think about as students is what it means to have this kind of argument in a context in which there are no clear standards. I mean, this is really up to the senators to decide, both on what the process should be, what the standards of proof and judgment should be as they make their decisions about how to vote. We don't have beyond a reasonable doubt operating here because Judge Kavanaugh is not in criminal court. It's not even exactly clear if he has the burden of proof, as some people have argued, to show that he deserves to be on the court and receive this huge honor, or whether it's really his accusers' stories who, whether they have the burden of proof here. I think we could argue about all of those things. I don't think there's a clear answer to any of them. I do think it's really important to keep in mind, and this is very obvious, but I'll say it anyway, we're talking about a lifetime appointment to the highest court we have in the land. And so, to me, keeping that out there as like remembering what is at stake here and what the goals are seems really crucial in evaluating what you think the answers to the questions I posed should be.
So just a brief follow-up, Emily. Two thoughts. One, historical. I'm old enough to remember Judge Douglas Ginsburg's failed nomination, which, from today's perspective, especially in light of changing views about marijuana use, seems strange. He was accused of smoking joints with his students as a junior professor at Harvard.
And in case since you guys probably don't remember this is the person who sandwiched between Bork's failed nomination and Kennedy's successful
nomination. And now, what was shocking about that revelation from my perspective is that people were having fun at Harvard Law School in the 1970s. That to me is unbelievable and casts some doubt on the allegations. But he was gone. This was a distinguished judge, someone who was an academic, who was well respected, who had clerked for Thurgood Marshall. Was considered a leading light in conservative legal circles, but had a strong libertarian bent. Seemed like he was going to be a clear confirmation, and then this thing comes up. And from today's perspective, that seems almost trivial. So I guess my follow-on question is, what does the world look like in the future? Does every nominee essentially have to hire a private investigator to do a full run-through, almost like what you do when you run for office? You do your own opposition research. You run all of the traps. Or is the answer that happens already, and this is just an exceptional case where, depending on which way you look at it, either something went awry or something didn't come out that should have come out?
Yeah, those are great questions. I mean, it's important to remember that 2 years ago, Neil Gorsuch had a very successful nomination in which his deep past did not get a lot of attention. And for any of the justices that are on the court right now, if there are these kinds of skeletons in the closet, and I really should say alleged skeletons, then they managed to sail through despite them. So I'm not sure we're setting an entirely new norm here. One thing I've been thinking about as a reporter is that some of these facts about Kavanaugh's, the culture he was part of at Yale when he was in Deke, the fraternity, and then in high school at Georgetown Prep, and also at Yale Law School, some of this comes from speeches he gave in ways that he was talking about drinking. Now, drinking is not the same as sexual assault. Don't mistake that. I'm not equating them. But I do wonder why we weren't reporting on some of this before, since some of those clips that are going around online now were publicly available over the summer. Now, maybe they were relevant in a context, or certainly a lot less relevant, where they weren't mixed up with accusations of sexual assault, and maybe that's fine. I can't quite decide what I think about that myself. But now that we're having people from his classes at Yale and high school come forward and talk about the kind of drinker he was, I think there are deeper questions about his veracity and the kind of blanket denials he made that do seem relevant. And I suppose for me, that seems like one more reason that you would want to investigate as much as you could before you gave this person such a high honor.
So I'll just close with a final thought, which is one of the reasons why I'm just a lawyer, but Article 2 of the Constitution does place this process in the political branches. And the president nominates and appoints with the advice and consent of the Senate. This is a process that is a political process, which is one of the reasons why, as a lawyer, it seems somewhat foreign, and there isn't much that I think I can add. I don't know what will happen in the minds of the various senators who are judging this, and they're not necessarily judging this as though there's a doctrinal answer or a clear legal answer. This is in the political realm. So with that introduction, let's turn to the substance. As has often been said, every time a new justice comes to the court or a justice leaves the court, it's a new court. And one of the potential trends that some have noticed is the court's increasing willingness to reconsider, which is a polite way of saying reverse or overrule, precedent from earlier eras. So I wanted to turn to Melissa to talk a little bit about stare decisis at the court.
Thank you, and thanks for having me. I realize this may not be quite as exciting a topic as where we began, but I personally think it's very, very interesting. And there has been a lot of focus because of where we are now with the confirmation process on stare decisis. I think that phrase probably hadn't been heard a lot outside of legal classrooms for some time, and my guess is that a very significant portion of the American populace now at least has some understanding of what that means because it's been front and center. But it has been a big part of what the court's been doing recently as well. Last term, there were two really big cases in which the court overturned prior precedent. There was Janus, which is a case about union fees, a First Amendment case, and then there was Wayfair, a case about when a state can tax an out-of-state business who is selling things online. And in both of those cases, the court overruled prior decisions from some, I think, in Janus, it was a case, 41-year-old decision, so it had been the law for quite some time. And in Wayfair, it dated back to the 1960s. Now, in Janus, it was a close decision. It was a 5-4 decision along what people think of as sort of the usual party lines. Wayfair was interesting because it was a case in which the Chief Justice was actually in the dissent, and Justice Ginsburg was in the majority voting to overrule precedent. I think that's an interesting point because we're trying to see what the court is going to look like in the coming years. And it's also interesting because if you look at the Wayfair decision, everybody on the court in Wayfair thought that the prior decision was wrong. It was just a question of whether wrong was enough and whether the change in technology was enough to overrule prior precedent, and that's really what the fight between the majority and the dissent were about. And so I think people are trying to read tea leaves to see what implications that could have for other cases that may be on the docket, either this term or in the coming terms. And in fact, there are already 3 cases for this term. The court's only filled about half of its docket, and 3 of the cases expressly in the question presented asks the court to overrule prior precedent. That's a lot. That's a lot for a term that is pretty small right now. There aren't that many cases. And so 3 of them are expressed, they're nothing as exciting as what you're hearing in the news, maybe nothing as monumental, but they are 3 cases that ask the court to overrule precedent. And so the first one is a case called Nick versus Township of Scott. I won't go into any of these cases in too much detail, but it's a takings case, and it's asking the court to overrule a portion of a prior decision called Williamson County, which was decided in 1985. And what Williamson County said was when you're bringing a takings case, you first have to exhaust your state court remedies and have the state courts tell you, or whatever the state administrative agency tell you, that they're not going to give you just compensation before you can come to federal court and say that there's been a violation of the takings clause. The idea being that the takings clause says that the government can't take your property without just compensation until the state has told you you're not getting any money. There has been no deprivation of your takings clause rights.
And practically a very significant decision because, I mean, as a law clerk at the court, takings cases come up all the time, and quite often one of the problems in the case is is it clear that they exhausted? So procedurally, that decision has blocked a lot of takings cases from coming to the court cleanly.
And it became an even bigger deal. So it was, it was a big deal when it was decided, but what really made it a big deal was a case the year I clerked called San Remo, where the Supreme Court said, once you've brought this state claim and the state has decided essentially the takings clause question, you can't then run into federal court because it has preclusive force and you can't relitigate. So the effect of the 2 decisions together is that you really, cannot bring the argument is you can't bring a takings claim in federal court, unlike pretty much a violation of any other constitutional right. And so that's the argument. And like most cases where the court's being asked to overrule prior precedent, there's some buildup to get there. There are some concurring opinions or dissenting opinions or some scholarship out there that's starting to criticize the prior doctrine, and that's exactly what happened here. It had been criticized in prior decisions by Justice Thomas in particular. And I say him in particular because actually in San Remo there was concurrence by 4 justices questioning whether that part of Williamson County should still be good law. But Justice Thomas is the only one still on the court, which is crazy to me because it doesn't seem like I clerked that long ago, but apparently I have. It's just a little bit depressing. But he's the only one still in the court, so we had to see where everyone else stands. But the fact that the court decided to take this case obviously means it's something that they're going to look at quite closely. The second one is a case called Gamble versus United States, and a double jeopardy clause one, also a really important one, and this one could have very significant implications. The normal, and I'm going to oversimplify this, and you can give some more nuance to it, but the normal rule under the double jeopardy clause is that you can't be tried twice for the same offense. If you're acquitted for an offense, you can't be tried again. There's a big, huge exception to this rule, which has to do with separate sovereigns. So if the federal government tries you for something, you're acquitted, the state can still try you for the same offense, and vice versa. This has existed for some time. It's been pretty, deep into the case law for quite a while, but a lot of scholars have questioned it. Some of the justices have questioned it, and notably a few terms ago, in a separate opinion, Justice Thomas and Justice Ginsburg, not 2 justices you see on the same side all that often, both collectively question whether that doctrine should be reconsidered. And so that is what the court is going to do in the Gamble case.
And how likely do you think it is that the court will overrule the separate sovereigns doctrine outright, or just limit it instead?
I kind of feel like when you have Justice Ginsburg and Thomas on the same side, that there's a better chance than not that there's some movement in the area. Whether they might find a way to narrow it, I think is possible. But I think it's significant they grant it. I think it's significant that they're coming at it from different places. And so, it's a pretty big issue. I mean, there's been scholarship, or maybe not, there's been articles written lately sort of questioning what impact this could have on the Mueller investigation, if there's any pardons that come out of the investigation. I think people thought that the states could maybe prosecute, whether that would have an impact on that. I'm not sure if there's an exact overlap, but at least there's really sort of an interesting discussion to be had about that. And dating ourselves again, as we did with the Ginsburg nomination, I mean, this was a big thing back in the Rodney King days in terms of the state being, there being an acquittal in state court and the feds taking over to prosecute. And so this could have really significant implications.
And much of the case law from the 60s in particular on the separate sovereigns doctrine really did arise in the context of civil rights cases where state court juries would acquit or maybe hang when civil rights claims were being brought, criminal claims were being brought, and then the federal government would step in and bring claims instead, criminal claims instead in federal court, and the court blessed that. So, but we're far removed from that era in some ways, but in other ways there are these applications that certainly are still important.
Right, and wanting to have that backdrop or that extra added protection. So it'll be interesting to see what the court does with that one. And then the third one in this overruled trilogy for the term is a franchise tax board, and that's about state sovereign immunity and whether to overrule an older case called Nevada versus Hall.
Is anyone here in Fed courts this semester? Okay.
Okay. So I will back up. No, so this is the issue.
Why aren't you in federal courts this semester?
Better question. So the issue here is whether states have sovereign immunity in state courts in other states. So here, Agency of California sought to collect unpaid taxes from a former California resident who is now residing in Nevada, and that individual sued the California agency in Nevada state court. And the rule under Nevada versus Hall is that there is no immunity in the courts of other states. And so this case has been litigated for like decades now. It has gone up to the court. This is the third time it's gone back to the Supreme Court. And when it was up there last in 2016, it had a couple other issues that were raised, but this was one of the issues raised, whether the court should overrule this prior case and see that there is immunity in other state courts. And that was a time after Justice Scalia passed away where there were 8 justices, and the court split 4-4 on that question, and so didn't decide it. And because it split 4-4, we don't know who is on which side. But, we know the court was equally divided then, and the court has decided to take up that same issue again now. And so, we'll see what the court does about it. So I think it's significant how many there are. I mean, in all of these cases, like I said, there's usually a process leading up to it. It's not generally something the court, hasn't said anything about, and then all of a sudden in one case decides to raise the issue on their own. It happens, but not all that often. And just because the court has decided to take a case about overruling prior precedent doesn't mean that they're going to do so. They did it a few terms ago in the securities fraud context, trying to decide whether they wanted to overrule this case. It was a Halliburton case, but a case about
Fraud on the market.
Which I will not get into. But they took it. Everyone thought it was going to be this huge deal, and then they just said, nah, we're going to stick with it. So,
That's actually what the opinion said.
Yeah, that's pretty much. It was a very short opinion. It would have been an easier read. Yeah. So it doesn't mean that they're definitely going to, but obviously they're going to give it a close look, and I'm sure there'll be a lot of tea leaves to read in terms of where the different justices stand on this. It's hard to generalize from these sorts of cases. Because it's not like there's one strict standard on when you overrule prior precedent and when you do not. But the justices do have, I think, somewhat different views as to how often you have to adhere to prior cases. Justice Thomas, for example, has very often written concurrences or dissents suggesting a willingness to revisit past precedents, past doctrines, and start things from first principles. And so I think particularly with the chief, and if we have a new justice on the court eventually looking to see how they decide these sorts of cases might tell us something about what's to come.
Thank you. So I will now turn to Allison to talk about what we might call the uneasy state of the administrative state. As many of you know, there's been certainly discussion in academic literature and now beyond about one of the centerpieces of the current way we structure the administrative state, the Chevron doctrine. But there are other issues bubbling up under the surface that are breaking through the surface now that potentially call into question the relationship, the structure of the administrative state and the relationship between the courts and the administrative state. And so I turn it over to you, Allison.
Thank you, and it's wonderful to be here. And I do want to pick up on something you said, Melissa. This is the third panel I've done in the last several months where all of the panelists had clerked for justices who are no longer on the court. And I agree, listen, we don't think of ourselves, I guess we're all older than we think.
Well, I'm
but there-
32, so.
But there has been, and we clerked together. I mean, that is, I think it's worth kind of stopping and thinking about the enormous amount of change that has taken place at the Supreme Court, and for that institution, an incredibly short length of time, to the point where when you and I clerked, now it's a changeover of 6.
Yeah.
There are 3.
And when we clerked, the court had been stable for about a decade.
Yes.
Yeah.
Yeah, so I think it's, so, and I think that, it impacts questions like stare decisis, because I think there's just if it's a new court with 1 justice, what is it with, 6? So I think that's just an interesting thing to keep in mind. So as Troy said, I'm going to talk about, as you elegantly put it, the uneasy state of the administrative state. And I'm going to look first at a trio of cases from last term, and then look at one case from this term that does have the potential, I think, to be a blockbuster in terms of the doctrine that, you poo-poo it, Troy, but the non-delegation doctrine, I'm sure a lot of these folks in the audience are here.
For the non-delegation doctrine.
Just for the non-delegation
Yeah.
doctrine. So the first sort of case and area I want to talk about, which has sort of been in the news and the commentary a lot, and that's the idea of judicial deference to agency action, which really is, I think, a linchpin of the administrative state. It takes a variety of forms, from Chevron deference, which we've heard mentioned. That's where courts defer to reasonable agency interpretations of statutes, to what's called Auer deference, deference to agency interpretations of its own regulations, even if made in court filings. And the first case I want to highlight from last term is a patent case. Don't worry, I'm not going to talk about the ins and outs of patent law, but because I think it gives an important glimpse into the issue of Chevron deference, particularly to the extent that Justice Gorsuch, as a Court of Appeals judge, expressed a great deal of skepticism about Chevron, and the case, which is SAS Institute versus Ianco. Sidebar, I've been told by counsel for SAS Institute that is SAS Institute, although I feel a little bit silly saying SAS Institute instead of SAS, which I think everybody calls it, but I've gotten drummed into me that it's SAS Institute. And that case involved the interpretation of a statute, the America Invents Act, that created something called inter partes review. It's a proceeding before the Patent and Trial Board that assesses the validity of a patent's claims. Now, the same day that SAS Institute was argued, the court considered a challenge to the constitutionality of inter partes review overall, based on, largely on separation of powers grounds. That was the Oil States case, litigated and lost by yours truly.
But valiantly litigated.
Valiantly.
Yeah.
I will say it was much more surprising to me that the court granted review in that case than the ultimate result. In fact, the then head of one of the officials at the PTO had been loudly proclaiming before argument that they were going to be vindicated, that the agency was going to win 9-0. So from an advocate, that was pretty good for me, because I'm like, if I could just pick off one, then I'll defy expectations, and ended up picking off 2, including the chief. So I was happy about that. Now, as was widely predicted, the court rejected that challenge over a dissent by Justice Gorsuch and the chief. So if Justice Gorsuch's view had prevailed in that case, there would have been no need for the court to decide the Sass case. And interestingly enough, Justice Gorsuch then wrote the majority opinion in that case. And again, I don't want to get into the weeds, but it dealt with basically a statute that said that the board shall issue a final written decision with respect to the patentability of any patent claim challenged by the petitioner. And the Patent Office had promulgated a rule that allowed the board in its discretion to choose to institute review as to only some of the claims. And so the question before the court was whether the statute requires the Patent Office to review every claim challenged in an IPR. So writing for a 5-4 majority, Justice Gorsuch held that this statute's plain text compelled the conclusion that the board has to review every claim. It can't pick and choose. So in a way, Justice Gorsuch's dissent in Oil States and his majority opinion in Sass, it's like the old joke about one person complaining about how bad the food is in a restaurant, and the other person says, oh yeah, in such small portions, too. You could sort of read it as, Justice Gorsuch saying, well, you want IPR? Okay, you can have your IPR. Justice Gorsuch concluded that when a statute's text is clear, when it carries a plain meaning, that it's the duty of an administrative agency to follow its commands as written and not to supplant those commands with others that it might prefer. So I think you can see in that language how really Justice Gorsuch was using textualism as a way to rein in agency discretion, totally outside of any discussion of Chevron deference. And in fact, I think in an attempt to catch the court's attention for review, Sass Institute had put the validity and viability of the Chevron deference squarely before the court, and had said that this case would present an opportunity for the court to revisit and potentially overrule Chevron. By saying that the statute was clear, Justice Gorsuch avoided any need to reach that issue, because Chevron only applies where you have an ambiguous statute. And so you might say that after, I think Sass Institute illustrates two things. I think clearly you had a justice writing a majority opinion who was on record at being supportive of revisiting Chevron, and yet at the end of the day, when there was no need to revisit it,
Didn't do it.
didn't do it, but also at the same time gave courts and litigants another tool in their quiver to rein in agency discretion with respect to textualism. If the statute is clear, you never get to Chevron deference. The issue doesn't arise. So you might say that Chevron has lived to die another day. So we'll have to see what happens there. Now I want to highlight a second case from last term that also reined in. You could say it reined in the administrative state, not based on textualism, but on structural constitutionalism, Troy, which you mentioned, and that was the Lucia versus the SEC case. And that case dealt with the constitutionality of the appointment of SEC administrative law judges, and whether those judges were officers of the United States, such that they could only be appointed by agency, say that had, I won't get into the weeds of that either, but it had to be appointed by the SEC commissioner.
As opposed to a low-level bureaucrat who had done the
Right.
appointing.
Right. And again, I think one of the stories in terms of interesting lineups, I mean, the Oil States decision, that was written by Justice Thomas, who has also written widely about being willing to revisit canons and doctrines that, in his view, have allowed the administrative state to grow beyond anything that would be recognized by the founders. But here you had Justice Thomas in the majority upholding IPRs. I think one thing you'll see in these types of cases is unusual lineups, and that was certainly the case in Lucia, where you had Justice Kagan writing for a 7-2 majority, just as in Oil States. That was the vote count there too. And the court there said, no, you cannot, it is unconstitutional, violates the Appointments Clause. I'll use your words, for low-level bureaucrats to be appointing other
I meant that
ALJ
nicely,
laws
by the way.
that exercise an enormous amount of enforcement authority. So if Sass Institute stands for the proposition that text matters, I think Lucia stands for the position that structure matters. And now, so you sort of have those cases from last term. And I want to look briefly at one case that's on the docket for this term, And unlike SAS Institute or Oil States or Lucia, I mean, it doesn't arise, sort of interesting in that it doesn't arise in the civil regulatory context. It doesn't involve sort of a garden variety administrative agency like the SEC or the Department of Labor or the PTO. It arises in the criminal law context, specifically the registration of sex offenders. And it doesn't involve, again, an administrative agency as we tend to think of them, but it involves a delegation to the Department of Justice. But depending on how the court decides it, I think this is one case that really has the potential to have astonishingly broad implications across a wide array of cases. And it involves a doctrine that I think when I was at law school at the University of Chicago used to be discussed in a course that was entitled Defunct Constitutional Doctrines. And that is the
I want to teach that class.
Yeah. All right, well, maybe there's going to be a smaller curriculum.
Formerly defunct.
Formally
Yes,
defunct.
formally.
Undefunct.
Formally defunct. And that's a legal doctrine called the non-delegation doctrine. Again, don't want to get into the weeds or the theory of it, but it basically says, Congress cannot delegate its authority to legislate to another branch. In terms of how defunct the doctrine actually is, the last time the court actually used the doctrine to invalidate a statute was 1935. All right. So the case is called Gundy, and it involves again, a challenge to a statute based on the non-delegation doctrine. And in a series of cases, the Supreme Court has sort of considered non-delegation challenges, but ultimately rejected them where it finds that Congress has given what it calls an intelligible principle for other branches of government to use in deciding how to exercise the legislative authority that's been given. And in 2012, in a case that you litigated,
Yes.
the Supreme Court avoided the issue in a case called Reynolds by holding that the Department of Justice had violated the Administrative Procedures Act by promulgating regulations under the Sex Offenders Regulation Act. So what the statute did was it said, in terms of whether the act applies to folks who were already required to register before the act was passed, we're going to let the Department of Justice make that determination. So the court, in another 7-2 decision, in a sense avoided reaching that because it held that the department had not validly promulgated its regulation.
It's even worse than that. So what the court, because the argument I'm a little bitter. I'm trying to get past it. I was working for the U.S. and I argued the case there. The argument, it was even before getting to the rule, the argument for the United States was that if you read the statute itself decides that it applies retroactively to people who were convicted of sex crimes before the statute was passed. The other side was arguing that no, the statute didn't do it. It delegated authority to the Attorney General to do it. And the court disagreed with the United States and said, no, the statute doesn't do it, it delegates authority. And then in a dissent, Justice Scalia and Justice Ginsburg said, no, we think the statute reads better, plus there's this wonderful canon of constitutional avoidance, and if it read the other way and it did delegate authority, there'd be a serious non-delegation problem.
Yeah.
Fast forward.
Yes, fast forward to a case, and I think, so the petition in Gundy raised four issues, and I think this issue was by all accounts kind of a tack on. I don't think anybody was expecting it to have legs, and so the court ends up granting the petition, and only as to the question that raises the non-delegation
And the facts in Gundy are actually somewhat sympathetic. This is someone who was convicted of a sex offense and was in federal custody. And his basic allegation was he was moved from one federal facility in Pennsylvania to another one in the Bronx, I think. And that move triggered the obligation to register. So his basic argument was, I was in your custody, and you're the one who moved me, and now you're coming after me for having failed to register. That was the crux of the petition. The fourth question presented was whether or not the delegation of authority to the Attorney General, to DOJ, violated the non-delegation doctrine, and it was not particularly deeply briefed by the Federal Defender's Office, and the brief in opposition from the Solicitor General was literally just a string cite of the 10 circuits that have rejected this position in published opinions, footnote, 2 others in unpublished opinions. So I don't think anyone saw this as a potential blockbuster case at the time.
No. So I think, so the question now is, you know, and I don't know, you can almost look at it sort of like an oil states Lucia, right? Is the case going to be in oil states where no one really expected it to be granted, no one really expected the court to take up the issue? When it did, 7-2 majority upholding the agency's authority, or is Gundy more like Lucia, where a 7-2 majority of the court says the constitutional boundaries were exceeded? So the case is going to be argued the first week. It's going to be argued October 2nd. So we may get a glimmer from how argument goes.
So we shall see. So I'm going to talk very, very briefly about the court's recent criminal law, criminal procedure cases. Now, this is a little bit, this is real short shrift because every term, the biggest single chunk of cases on the docket tend to be criminal law and criminal procedure cases, sometimes up to a third, even 40% of the docket. And, you know, when Allison and I were clerking, I would have told you that the court had a particular view in Fourth Amendment search and seizure cases. That view was not the defendant loses, I wouldn't say that, but that the court was not looking to innovate. The court was looking to apply standards that tended to be all-inclusive, all-circumstances type standards with a fairly high level of deference to law enforcement. So if you were bringing a Fourth Amendment challenge and you were the defendant, you typically had an uphill battle because in the first instance there would be a lot of deference, and then there would be other doctrines built in, good faith and the like. Something is perhaps happening at the court that may be changing that understanding of the way the court deals with the Fourth Amendment. And the main case I wanted to highlight is Carpenter against the United States, which many of you have probably read. So Carpenter held that the government's acquisition of cell site records, which pinpointed the location of the defendant when he was using his wireless service, was a Fourth Amendment search, and the government not having obtained a warrant supported by probable cause before acquiring those records would essentially have to find some grounds to justify the constitutionality of that search. That was a 5-4 decision. The majority opinion was written by the well-known left-wing pro-defendant justice known as Chief Justice John Roberts. You may have heard of him. He's the one with the tie-dyes and everything. Now, and in some ways, this is not a surprise because Roberts wrote the last big case involving cell phones in which the court, in some ways, moved away from its prior precedent about what happens when you arrest someone and then you search, and if you find the wallet, the police can go searching through the wallet. Well, the question was, is that true for a cell phone as well? Can the police go searching through the cell phone without it being a Fourth Amendment moment? And the court said no. The court said, cell phones are different. It's like a computer that has your entire life on it. And some of that reasoning has now ported over into Carpenter. The other thing that's interesting about Chief Justice Roberts' opinion is his seeming categorization of this case as a new technology case, which fits in the same category as the Jones case from now several years ago involving a GPS device that was planted on a defendant's car. The court said that is also a search for Fourth Amendment purposes. And when looking for analogies, Robert says, we think what happened here is more like a GPS. There's so much information about location. Even though it's not pinpoint, it's pretty extensive, and accordingly, it crosses some threshold, which we're not going to really make totally clear, that suggests there's a Fourth Amendment issue. So I'll end there, but just note that this seems to now have set up a potential division on the court. The question is, will other Fourth Amendment doctrines be reconsidered, or more likely, will the court develop a new subcategory of Fourth Amendment cases where the question really is this a new technology case, where technology seems to be so invasive that we have to cabin the technology with somewhat more restrictive and less deferential doctrines. So we have a few minutes before we take questions. I just wanted to get just a very, very short discussion on two other areas. One was the court's continuing expansion or continuing treatment of arbitration in civil cases, and then a little bit about gerrymandering, voting rights, and the like. So, Melissa, can you just lead us off in a short discussion on the court and arbitration?
The court loves arbitration.
Thank you.
Let me
The more
rephrase.
binding, the better.
Majority of the court
Oh.
loves. Yeah, exactly.
Majority of the court loves
The
arbitration.
majority of the court loves arbitration. It is actually pretty remarkable, and I don't think it's always been the case. I think you can go back not all that long ago, in terms of a few terms ago, and have there be arbitration cases that have been before the court that were unanimous or close to unanimous. But in recent terms, it is a pretty big division among the justices on the court, and arbitration has been winning every time.
How many of you here have taken complex litigation yet? Okay. So the reason why this, of course, is important for 1Ls or those who haven't taken complex litigation yet is that an arbitration clause is an indirect way of preventing the certification of a class. Because in a consumer contract, every single person in this room is a counterparty to a consumer contract, at least one consumer contract that contains an arbitration clause. And that arbitration clause typically will have a provision that says any arbitration will be one-on-one, not as a group. And the court has said that in those circumstances, you cannot have an aggregate proceeding like a class action, even if it's within the arbitral forum. So for many companies that deal with the general public that want to avoid having to defend class actions, putting in an arbitration clause with the purpose of breaking up essentially aggregation is something that has now been blessed by the court.
And not just in the consumer context. The big case from last term was in the employment context, where employers like to do the exact same thing. And so the big question in this Epic Systems case last term was whether that's something that employers can do or whether it violates the National Labor Relations Act. And so it's somewhat pit the NLRA against the Federal Arbitration Act, and was several cases consolidated before the court, and by 4 the court said, no, arbitration wins.
Shocking.
And shockingly, shocking. And that case is actually, I think, a very good example of why there was a difference between having, I'm predicting, but having a Justice Garland on the court versus Justice Gorsuch. It was a 5-4 decision. It was granted at a time where Justice Garland's nomination, I believe, was still pending at the time. And that shift, I think, had a pretty significant impact on that particular decision. And so, the court decided that you can have this in employment contracts, and already for next term, there's 3 cases on the docket involving arbitration. In all 3 cases, the Court of Appeals went against arbitration for a variety of different reasons. They all raised their own issue, but the consistency among all 3 of them is the Court of Appeals said no to arbitration or no to an arbitrator deciding something. And in all 3 cases, there was a cert petition, the court granted, and They're all being argued in October. I think one is in the beginning of the month, and then there's two on October 29th, so it'll be arbitration day in court. Individually, they each raise their own issues. One of them does sort of intersect with the class question, which is you can agree to arbitrate disputes on a class-wide basis, but the court a few terms ago said
Has to be explicit.
it has to be, you can't just be silent about it. It has to be clear. And the Ninth Circuit, in a split decision, said, well, we think there's some ambiguity here, and in California, you construe ambiguity against the drafter, so we're going to allow class arbitration. The dissent called that, I think, a palpable evasion of Supreme Court precedent. The court granted, and here we are.
We know
So-
it'll happen.
So, yes.
So finally, Emily, if you could just talk for a couple minutes about the blockbuster cases from last term on gerrymandering and the blockbuster opinions they produced.
Sure. I want to start, though, just by piggybacking a little bit onto Melissa. These cases that you're talking about are hugely important in terms of people's access to court, whether it's consumers or employees. Epic Systems was one of the sleeper cases from last term, and this whole line of cases, which didn't exist when I was in law school, matter enormously in terms of the power of corporations in the country versus consumers and employees. So you should totally keep an eye on these three that are coming up in October, even if we think we know how they're going to come out. So voting rights and gerrymandering have become also enormously important issues in front of the Supreme Court. And basically what happened last term was that a door that was just a little bit ajar shut. Justice Kennedy years ago had signaled at least some possible receptivity to the idea of having courts police partisan gerrymandering. So this is the world of one party or the other has a majority in the state legislature and usually also controls the governor's office and then draws the lines for new districts after the census in a way that really helps it win elections, like way beyond what you might get from proportional representation. Wisconsin was the state whose state assembly map was before the court this term. And because of Justice Kennedy's previous possible signaling that he was interested in a kind of social science method, a test, a measure, or several measures that might allow courts to responsibly address extreme examples of partisan gerrymandering, a lot of political scientists and computer scientists got into the act and produced various measures that that they thought and that the plaintiffs thought, the voters in Wisconsin thought would at least allow courts to put a halt to extreme partisan gerrymandering, to wringing as much partisan advantage as you possibly can out of your state map. That didn't happen. Either Justice Kennedy changed his mind or maybe he never meant it to begin with. But we ended up with this weird punt that looked like a unanimous decision but really was 5-4, in which Justice Kennedy sided with conservatives on the court and the four kind of liberals tried to argue that, well, there would be another way to bring this case with a slightly different posture. Maybe it could still come out in favor of the plaintiffs. But I think really this is one of the important issues that's at stake with this Supreme Court nomination, that if we have a strongly conservative majority, the court will shut the door on the idea of judges trying to prevent state legislatures from redistricting to great partisan advantage. And if that's something that you think is a problem for our political system, and there are reasons to worry about the effect that partisan gerrymandering has on competitive elections, there is another potential remedy, at least at the moment, available, which are ballot initiatives that turn redistricting over to independent, nonpartisan commissions. Arizona has a commission like that, California, a couple other states. There are actually 5 states, including, I think, Missouri and Colorado, Michigan, that have ballot initiatives like that on the ballot this year. So that's an alternative. I should say, though, that it's an alternative because of a 5-4 decision from 2015 that upheld the constitutionality of these ballot initiatives over a challenge.
It's an Arizona case.
Exactly. And that 5-4 had Kennedy siding with the liberals and Chief Justice Roberts in quite impassioned dissent. So that's another case that could change, depending again on the composition of the Supreme Court. And so if you take that one more step, you could imagine a world in which, aside from having a state legislature decide to hand over the power of redistricting to a commission, which is like a harder sell than a ballot initiative a lot of the time, right? Legislators don't often give up lots of political goodies on their own. If you can't accomplish that, and you can't accomplish a national constitutional amendment, that was the other door that Chief Justice Roberts left open, then we're just going to have more and more partisan gerrymandering in this country. And national constitutional amendments aren't really a thing anymore. We haven't done one
been a
for
while.
We
quite
don't-
a while.
We don't, the last time we did that, there were like skinny ties. Oh, they're back again, actually. There is one other potential route, although the Arizona redistricting case, I think if Roberts' view had prevailed, might also be problematic. And that's state Supreme Courts or state courts interpreting their own constitutions to strike down partisan gerrymanders, which is what happened in Pennsylvania this past year. So we have a few minutes left, and I wanted to open the floor to questions. There are microphones in each aisle. I know some of you are going to be running out for class, but if you have a question, you can come down to the mic, and we'll try to answer if anyone has any questions. Anyone has any questions? Okay. Should I resort to the Socratic method? No, I wouldn't do that. Oh, there is a question here. Okay, let's see.
Hi, thank you so much for...
I know you.
Yes,
Yeah.
yes.
Yeah.
I just wanted to complain that all of this is very unfair.
Yeah. Oh. Ooh.
No,
Ooh. It's inside joke in my class. Yes. Yeah.
We've talked a lot about this this issue of like that the composition of the court is ultimately a political question, and also getting into issues like wait, let me rephrase that. So I'm wondering about the role of like increasing partisanship and polarization in like its effect on the institutions or the institution of the court or the judicial system, in that it seems that increasing polarization is making it making it less taking away the legitimacy of like the courts as sort of an independent arbiter of the law. So whether it's that both Republicans and Democrats wanting to appoint justices that have their same ideological views, regardless of whether that's a valid view of the law, or if it's issues like gerrymandering, which was not as significant, arguably was not as significant a problem in the past because voters were not polarized along political lines to the same degree. And so now the court has to decide this question that it's going to decide along partisan lines that in the past did not create the same degree of issue.
So a quick thought on that. Well, one thing is that in a previous era, appointments to the court tended not to fall along ideological lines, but that's because the political branches cared about other things. So I'm old enough to remember within relatively recent memory of my youth when there was a Catholic seat on the court and a Jewish seat on the court, and you needed someone from the West, and you needed at least a Southerner. In the 19th century, there was always a Pennsylvania seat, and then there were maybe 2 New York seats. People got on the court because they were owed a political favor, which is really how Chief Justice Warren got on the court, or you were trying to kick them into the long grass to keep them out of the political arena. That's a lot of 19th century court appointments. So there was a level of kind of happenstance and political calculation in putting people on the court that tended to sort of disrupt easy lines of decision-making. So what polarization does only matters to the extent that appointments to the court also are falling along more ideological lines as opposed to these other factors that tend to blend decision-making at the court.
So I've been worried about it falling more on ideological lines as well. And before coming here, I went to look back because I had this recollection of there being, better days where things weren't quite as polarized and
Sunshine,
and sunshine,
lollipops.
everything was wonderful, everyone got along. Obviously, that's not completely true, but, looking back at prior confirmation battles for the Supreme Court, I just pulled, Justice Stevens was confirmed 98-0, Scalia was confirmed 98-0, Kennedy was confirmed 97-0. I can kind of go on all the way up until even the chief was 78-22. And then kind of the wheels came off. And of course, there were failed nominations during that time as well, so, that doesn't paint the full picture. But I do think there has been a pretty fundamental shift in recent years in terms of the confirmation process for the court, as well as some of the lower courts, but mostly for the Supreme Court. And I don't know, I do think if you want to look at the court as an independent institution, the more confirmation battles get drawn out, apart from what's going on in terms of personal quality and character, but beyond judicial temperament and the like, and the more it starts looking political, I do worry about the impact it has on people's perception of the court.
Emily?
Yeah, I think that the two things you raised are related to each other. So we have much more polarized parties now than we did certainly in the 70s when Stevens became a justice. And that's having an effect on the confirmation process because the bases, particularly the conservative base, which has just been much more attuned to the court, much better at organizing around the court, they really care about it. And the Federalist Society exists essentially to make sure that someone like Justice Stevens or Justice Souter or Justice Brennan or Blackmun or Chief Justice Warren is never again chosen by the Republican Party. Like, that's the deal. And I think it will be really surprising if that changes. And, a real mistake from the point of the Republicans is made because the vetting process, even though it's having its challenges right this minute, in terms of ideological bent and record, is just, it's doing something really different than it was doing before when in the kind of days that Troy was describing. And I would argue that our entire modern understanding of the court since the late 1930s is based on a notion of nonpartisanship that relies on the figure of the swing justice and the figure of the justice who drifted from his ideological moorings, at least in terms of the president who appointed him or her. And I don't think that we're going to live in a world in which those people exist anymore. There are actually 10 of them, if you go back, by my count at least. There are the five justices I just named, who I would argue are all Republican appointees who drifted far enough to the left that they essentially acted like liberals. And then there are 5 justices, Kennedy, O'Connor, Byron White, Stewart, and Powell, who were unpredictable. They were swing justices. And 4 of those 5 people were also Republican appointees. So if we live in a world in which Republican presidents appoint solid, strong conservatives, that is going to be a different court and a different society. We don't really know what that looks like yet, but it's going to be very uncomfortable for people who want the rule of law and the kind of law that the Supreme Court makes, especially in the decisions that the public actually cares about and pays attention to. If we want that to look like something different than politics, we're going to have to come up with some different understanding of the court. I don't really know what that's going to look like, but I think that's why folks up here are concerned.
So we have time for a very brief question with a 1-minute answer from someone.
Okay, great. This is a very directed question. I was really interested in when you were talking about the Gorsuch dissent in the oil states case and then the majority opinion in the Supreme Court case. Does that happen a lot where Supreme Court justices will kind of end up on a different side in a similar case once they're on the bench?
Can you think of one like that?
No. I think no, they're sort of simple, they're sort of straightforward.
Yeah.
Okay.
Yeah.
No.
It's a good question.
But I do, just quickly, I do think, in response to something you said, Emily, in terms of the court, I think that it's kind of like oral argument. People are fixated on oral argument because that's the part of the process that's most visible, when I think most court watchers will say that's kind of.
10% maybe.
10% of what happens in a
That, yeah.
case.
Public,
If that,
yeah,
if
meaning
that.
less effectively.
And I think, looking at the terms cases, looking at the court's cases and how they're decided, I think you're exactly right. It's because, in the portion of the court's docket are these cases that the 5-4, that divide along ideological lines.
Right. Publicly
But
salient cases.
Publicly salient cases, all this attention is focused, and yet a whole raft of cases where you have interesting lineups, and you have cases, like, right, where, you have Justice Ginsburg joining Justice Scalia in dissent. You have Justice Gorsuch coming out in a different way than Justice Thomas does. Those tend to fly under the radar. And so I think it's sort of easy to see why there's this perception of the court as highly politicized in a way that I don't disagree with in terms of kind of the hot-button cases that get the focus, but I think that view is incomplete because it really doesn't see a wide variety of cases that are unanimous, or if you have interesting non-ideological lineups that really are the biggest part of the court's docket.
So we have come to the end. Please join me in thanking our panel.